in the judgment handed down this morning in the Court of Appeal. Mr. Speaker, the Court of Appeal has ruled that in the light of disclosures by a United States court in December 2009, which I shall describe below, the 7 paragraphs which have been redacted from the original judgment of the Divisional Court in this country of the 21st of August 2008 should be published. The 7 paragraphs contain summaries of American intelligence relating to Mr. Mohamed's case held in UK files. I accept the Court's ruling, which concludes a very complex and in various ways apparently unique case, and have made the relevant paragraphs available this morning on the Foreign Office website. Mr. Speaker, the judgment is significant not just in respect of the 7 paragraphs, but also for important principles which are at the very heart of both our national security and our democracy. The facts are as follows, Mr. Speaker. Mr. Mohamed, an Ethiopian national, formerly resident in the UK, was detained in Pakistan in 2002. In 2004, he was transferred to Guantanamo Bay. In August 2007, my right honourable friend, the then Home Secretary, and I wrote to the US Secretary of State to seek Mr. Mohamed's release from Guantanamo Bay and his return to the United Kingdom, along with 4 other UK residents. Mr. Mohamed was released from Guantanamo a year and a half later, in February last year. Mr. Speaker, in May 2008, Mr. Mohamed brought proceedings against the British government in an effort to secure disclosure to his legal counsel of any material held by the British government that might assist in the defence of his case before a US military commission. The question at issue in our appeal against the judgment of the Divisional Court was not this disclosure, which we supported and secured. It was instead whether the intelligence provided on a confidential basis by one state to another, in absolute trust that it will be kept secure, should be disclosed into the public domain in the interests of open justice, or whether instead the breach of trust would be so grave as to endanger intelligence sharing relationships and therefore affect national security. As I have said in this House on a number of occasions, in this case it was US intelligence and an English court, but it could just as easily be British intelligence in a foreign court. As I have also said to the House often, at issue in this case was not the content of the 7 paragraphs, but the principle of their disclosure by an English court against US wishes. Mr. Speaker, I am grateful for the consideration the Court of Appeal gave to the control principle. This principle, which states that intelligence belonging to another country should not be released without its agreement, underpins the flow of intelligence between the US and the UK. This unique intelligence sharing relationship is vital to national security in both our countries. Crucially, Mr. Speaker, the Court has upheld the control principle today. The judgment describes that principle as integral to intelligence sharing. It specifically vindicates the careful assessment that releasing the 7 paragraphs without the consent of the United States would have damaged the public interest. It also specifically makes clear that, and I quote, "This litigation has endorsed the application of public interest immunity and the maintenance of confidentiality over secret information. This is important for the future of intelligence sharing with the US and with others." However, on the 17th of December last year, we received notice of a US court ruling in the case of another Guantanamo detainee, Fahi Saeed bin Mohamed, which made a finding of fact in respect of Binyam Mohamed's allegations of mistreatment. That judgment does not set out the content of the 7 paragraphs per se, but it does include references to the treatment of Mr. Mohamed covered in the 7 paragraphs. We brought this to the attention of the Court of Appeal and Mr. Mohamed's counsel immediately. The Court of Appeal today ordered the publication of the 7 paragraphs because, in its view, their contents were placed into the public domain by a United States District Court. Without that disclosure, it is clear that the Court of Appeal would have upheld our appeal and overturned the 5th judgment of the Divisional Court. The Court of Appeal was also clear that the judiciary should only overturn the view of the executive on matters of national security in the most exceptional circumstances. It states, and I quote, that it is integral to intelligence sharing that intelligence material provided by one country to another remains confidential to the country which provided it, and that it will never be disclosed, directly or indirectly, by the receiving country without the permission of the provider of the information. This understanding is rigidly applied to the relationship between the UK and the USA, unquote. Mr. Speaker, I spoke last night to Secretary Clinton about this case. It has been followed carefully at the highest levels in the US system with a great deal of concern. Recent events have shown the importance of the US-UK intelligence relationship in the fight against terrorism. Equally, the determination of the US authorities to protect the confidentiality of their intelligence has been absolute throughout this case. We will work carefully with the US in the weeks ahead to discuss the judgment and its implications in the light of our shared goals and commitment. Mr. Speaker, mistreatment of prisoners, not to say torture, violates the most basic principles of this country, never mind our national and international legal obligations. There is a fundamental commitment on the part of myself, responsible for the Security and Intelligence Service, and my right honourable friend, the Home Secretary, responsible for the Security Service, and the heads and staff of these agencies, to uphold the highest standards of conduct, not just for ourselves, but with the countries with whom we cooperate. A wide range of allegations have been made during the course of this case. Today, some of the facts can be publicised, in some cases for the first time. First, the paragraphs released today describe information received by our intelligence agencies concerning the conditions of Mr. Mohamed's detention by the United States in Pakistan in April 2002. They note specifically that he was subject to sleep deprivation, that he was subject to threats and inducements, and that he was held shackled, and that the treatment, were it conducted by the United Kingdom, would be contrary to undertakings first given to this House in 1972. To repeat, it was not conducted by the UK. Second, now that they are in the public domain, it will also be evident that the paragraphs do not contain information on Mr. Mohamed's most serious claims of mistreatment, notably in respect of alleged genital mutilation, during his detention until his release from Guantanamo last year. We, the United Kingdom, have no information to corroborate those allegations. These matters have been raised quite properly by Mr. Mohamed in his civil claim for damages and will be addressed there. Third, during the course of these proceedings, allegations of possible criminal wrongdoing by a British official were made. The Home Secretary referred these allegations to the Attorney General for her consideration, and they are now the subject of a police investigation. Mr. Speaker, the most basic values of this country are at issue in the debate that will follow the Court's decision today. Our position is clear. The UK firmly opposes torture and cruel, inhuman and degrading treatment or punishment. This is not just about legal obligations. It is also about our values as a nation and about what we do, not just what we say. We have taken a leading role to eradicate torture internationally, both through organisations such as the United Nations and by assisting other countries. Where possible wrongdoing is found, it is fully investigated. Mr. Speaker, I also want to place on record that we are lucky to have the best intelligence agencies in the world. Their staff are second to none in their commitment and in their public service. They are respected across the world, and the work that they do to keep Britain safe deserves all our admiration and gratitude. But there is a further and fundamental myth that needs to be addressed. It is that the security services operate without independent oversight. Mr. Speaker, ministers and agency heads have the first responsibility for the conduct of their organisations. The Intelligence and Security Committee provides parliamentary scrutiny of agency activities. Independent judicial oversight is provided by the commissioners, who by law must be given access to whatever documents and information they need. Both report annually to the Prime Minister and to Parliament. Then there are the courts, whose role is to protect the rights of individuals and provide recourse to justice when they think they have been infringed. This they have done and continue to do in this case. This judgment today is not evidence that the system is broken. Rather, it is evidence that the system is working and that the full force of the law is available when citizens believe they have just cause. The 6 judgments in this case show, plus a closed judgment, show a seriousness of purpose in our legal system that is a vital part of our system of accountability. Mr. Speaker, we have fought this case and brought the appeal to defend a principle we believe is fundamental to our national security, that intelligence shared with us will be protected by us. No one likes to lose a case, but the force of this judgment is that it firmly recognises that principle, and that in doing so the Court is fulfilling its vital constitutional role, protecting this country and upholding the law.